Hello there and welcome. This is the Disability Law Show. Good to have you back with us for another week. Scholes here and James Fireman, disability lawyer, of course, at disabilityrights.ca. You can always reach out to James and the team anytime. Consultations will not cost you a penny, which is a nice benefit. 1-855-821-5900, help at disabilityrights.ca to get a hold of James and the team. We'll give that out throughout the show. Over the course of the next half hour, we got emails to get through, conversations, phone calls, main topics, which, by the way, this week is returning to work after disability leave. Know your rights. That is on the way in just a bit, but something we haven't talked about in quite some time. In fact, I can't quite remember last time we covered it, James, was punitive damages, what they're all about. What do you say about that? What do you think?
Well, it's a really interesting topic because one of the things that people ask about all the time is, why is it that when you're talking about cases on the show, the insurance company is always so eager to come to the table and settle, but when I'm trying to fight myself, when I'm trying to fight the insurance company, they're not? And punitive damages is one of the biggest reasons why there is a difference. Punitive damage is an award that a court can give in cases where the insurance company has not acted in good faith. Insurance companies have a duty to everyone that they insure to be fair, to act in good faith. And when they fail to do that, the courts can award punitive damages. It's punishment for their bad behavior. And so because of that, what it means is as soon as you start litigation, as soon as you start a lawsuit, there is the potential for the case to wind up in court. And in that scenario, a judge can award punitive damages, which means that the insurance company, who all along has thought, well, what's the worst that can happen? Worst that can happen is I have to pay out the benefits that I'm saying they don't get, so I'm no worse off. Now, all of a sudden, that you've started litigation and there's the potential to wind up in front of a judge, now they have much more exposure because a judge can say, no, no, no. You have to pay those benefits, but you also have to pay these punitive damages on top of it because you did not act fairly. You did not act in good faith. And because of that, insurance companies want to avoid going to court at all costs, which is why the moment you start litigation, insurance companies change their posture very, very quickly. So what are we talking about in terms of punitive damages? Where do we see it? Well, if you read most case law in other areas of law, and they'll talk about punitive damages as being a really exceptional award, something that you see incredibly rarely. But very strangely, if you were to look at long-term disability cases, which are very few and far between, long-term disability cases wind up going to court maybe 4 or 5 times a year across the country. Wow. It's exceptionally rare. But when they do, it is actually the exception to not see punitive damages awarded. Over the last 10 years, we've seen this repeatedly. The cases that do wind up in court almost always find that the insurer has acted in bad faith and award punitive or other kinds of damages as a result. So what kind of conduct can the insurance engage in that might attract punitive damages? Well, one of the things that we see frequently is ignoring evidence, particularly the evidence of a treating doctor. So if your treating doctors are all saying that you have this disability and it's causing these functional limitations, and those are preventing you from being able to work, and the insurance company just ignores that, either because they're relying on their own consultant, who usually has never seen you before, or they're not even doing that much, then a court might find that that's bad faith. That is pretty typical. We see that on almost every case. Then there are other things too. You'll see insurance companies cherry picking information. So they may get a consultant's report, or they might even have you assessed by an expert. But rather than take the entire report and rely on the actual opinion of their consultant or expert, they'll cherry pick very specific details out of the report and use those details as a basis for denying the claim, even though if you were to read the entire report, the balance of it suggests that the person is disabled. That is acting in bad faith, cherry picking. Then there are other things where the insurance company is going even further, where it's actually like they're manufacturing the evidence for a denial. They're essentially getting reports that are designed to set up a denial, where it is literally the process itself is guaranteeing that they're going to reach a result where they can say, see, you're disabled, even though the process itself was unfair. We see that on occasion. And then there are other things as well where there's just such a level of incompetence that a judge that would be presiding over the case would say, this goes beyond just poor judgment or an incorrect result. This is systemic. This is something that the system is set up either because you haven't trained your people properly enough, or the process that they're trained on is designed to set up a result that will be unfair. Those are all things that I'm looking for every time I open a case. And I will argue that every single time. Anytime I see any of those elements in a claims file, when I come to the table with the insurance company at mediation, that is the first thing I'm starting with. I'm not talking about whether or not my client is disabled. They are disabled. The treating doctors say they're disabled. Then who is going to say otherwise? Who would a judge listen to? A treating doctor or someone else? And as long as a treating doctor has said it, I'm not even arguing about whether or not my client is disabled. I'm arguing about the bad faith. I'm arguing about the things the insurance company has done that are fundamentally unfair, that violate the duty of good faith.
So when it comes to punitive damages, do you make that call, or does the court say, oh, by the way, including the benefits that you're going to pay because you should have, also here's some punitive damages to go along with? Or is that something you make the call for?
Well, certainly if it ever got to trial, right, that would be something that a judge would have to decide on. But again, it's exceedingly rare that these cases ever wind up anywhere close to trial. Long-term disability cases virtually never get close to trial. When they do, there is actually a reasonable expectation that there's going to be punitive damages, which is unusual. But before that happens, when most cases for long-term disability resolve, they resolve at a mediation. And at the mediation, that is going to be a fundamental part of what I'm arguing, what I'm presenting to the mediator and to the insurance company, that the insurance company shouldn't want this case to go any further. Because if they do, if this case ever gets in front of a judge, they're going to have to reckon with how they handled the file. They're going to have to value the file inclusive of some form of punitive damages.
And from what you've seen in the past, can these damages, like it's a few shekels here and there, or it could be a substantial amount of money? Well,
the most recent case that dealt with punitive damages was a long-term disability case called Baker, and they awarded $1.5 million in punitive damages. Now, I'm not saying that every case that is in front of a judge where they find bad faith is going to award $1.5 million in punitive damages. Right. That's not realistic, and the circumstances in that particular case are particular. Mm-hmm. But measured against those circumstances, there is a spectrum of damages, and where you fall on that spectrum, you would argue on a case-by-case basis, but it can be very substantial.
Wow. By the way, anytime before you make the phone call to James and his team, pocketdisabilitylawyer.ca. It's an interesting website. It's anonymous. It's really simple to use. You're a drop-down menu, ask you a bunch of questions, and at the end says, yeah, proceed, you have a case, or you know what, you don't have to proceed, and nobody knows you were ever there. Pocketdisabilitylawyer.ca. Use that even before the phone call to James and his team. Real simple to use. Wanted to get that out of the way. I mentioned some phone calls, some audio throughout the half hour. Let's get to our first phone call today and see what's up. Here we go.
So I'm on LTD. My LTD finally just had sent me an email saying that they want me to apply for government disability. One, I'm wondering, do I have to do that? And two, what happens if I get turned down by government disability? Are they now able to say, well, they didn't pass you, now, we can drop you?
It's a great question.
Yeah, it is. So typically when insurance companies start asking you to apply for government disability, what we're usually talking about here is CPP disability. So if you've been paying into the Canada Pension Plan and you become disabled from work, you're entitled to apply for CPP disability. You don't have to wait till you're 60 or 65 to do that. You can apply as soon as you become disabled. Now, the test for CPP disability is a little bit more difficult. It requires a severe and prolonged disability. That is going to be a more difficult test to meet than the typical test under a long-term disability policy. And so if you are approved by the government, Service Canada, they handle CPPD applications. If Service Canada approves your CPP disability application, then you should be entitled to long-term disability benefits with your private insurer as well. It's not always the case. There are certainly circumstances where a private insurer will ignore that and say, well, we find differently. And they are entitled to do that as well. But the reason they want you to do it is because if you're approved for CPP disability, the insurance company is entitled to offset that amount against what they owe on a monthly basis. So let's say, for example, that you are getting $4,000 a month from your long-term disability insurer, and you get approved for CPP disability for $1,500 a month. Well, CPP disability starts paying you $1,500. That doesn't get added to the $4,000. Your insurance company is going to say, all right, well, we're now only going to pay you $2,500. The net result is the same. But you want to apply for those benefits anyway, even though it's not putting more money in your pocket, because if you don't apply for those benefits, almost all disability policies have a provision in there that says if you don't apply for CPP disability or other government benefits that you might be entitled to, then your insurance company can presume you would have been approved and estimate what they believe you would have been approved for and take that as an offset. Wow. So you don't want to give them that opportunity to just reduce your benefits without you actually getting the CPP disability. Now, what happens if you apply and you're denied, as this person has very, very intelligently asked in this question? Well, if you're denied CPP disability, your insurance company certainly is not entitled to offset a benefit that you're not receiving from the government. That's for starters. Your insurance company may then say, well, you know, the government says that you're not disabled, so we don't either. But that really isn't a valid argument. Again, the test for CPP disability is more onerous. It is just a more difficult test to pass. And so the fact that you've been denied CPP disability does not mean that you are not going to be entitled for your long-term disability benefits. There are three buckets. There is you are disabled for both CPP disability and long-term disability. Right. There is you're not disabled for CPP, but you are for LTD. And then there is you're not entitled to either benefit. And so you can absolutely be in that middle bucket where you don't qualify or you're not, you don't have a disability that entitles you to CPP disability, but you are entitled to long-term disability benefits. So that's the long answer. The short answer is this. You should apply for the CPP disability benefits. I would also apply for the disability tax credit, because if you are approved for CPP disability, that is a taxable benefit. And so to avoid paying that, you want to also apply for the disability tax credit. It is also a federal government program, but it's run through a different ministry. You have to apply through the CRA for the disability tax credit, Service Canada for CPP disability.
So let's assume you're getting both. You're getting your benefit from the insurance company. You have been approved for CPP disability. Somewhere down the road, say close to the 2-year mark, right? Your insurance company cuts you off or says they're going to cut you off. Do you also lose the CPP, or is that more robust and you're kind of, at least you got something coming in, right?
No, they are independent. And so much like your insurance company doesn't have to accept the decision of the government in terms of what they've decided for CPP disability, Service Canada certainly doesn't rely on what your private insurance company decides in terms of your LTD benefit. They are different tests, and they do apply those tests independently of each other.
So I'm not really hearing a drawback for applying for CPP, especially when you have to with your insurance company.
No, the only drawback is just going through the process, completing the forms, submitting them, and understandably, a lot of people bristle against the idea of getting a benefit that's really to the benefit of the insurance company that you're not getting anything extra for. And I do understand that. I understand that notion. But the reality is, if you play it out, you're never worse off for having applied, and you can be better off, especially if your LTD winds up being denied or terminated. At least you have that as a safety net.
First segment done. Short break. We'll get back into lots more. In fact, our main topic as well, which is returning to work after disability leave. Know your rights. That's coming up with James and myself. Stick around. More of the Disability Law Show is just ahead.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back, Disability Law Show. Thank you for sticking around through the break. James Fireman, always available, disability lawyer, of course. Use the number, 1-855-821-5900, of course, toll free. The consultation is free as well, so there's nothing holding you back from making the phone call. Double it up with the email, help@disabilityrights.ca as well. Main topic time. Here we go, James. You'll love this one. Returning to work after disability leave. Know your rights. Number one, if your doctor says you're not ready, your doctor, your LTD provider cannot demand you return to work prematurely. They do not overrule the medical team.
Yeah, your long-term disability insurer can't force you to do anything. This is, I bump on that kind of language every time I hear it. Can my insurance company force me to go back to work? Can they force me to do, well, they can't actually force you to do anything. The only thing that they can do is withhold your benefits. That isn't forcing you to do anything. That might be putting you in a very difficult position financially, and that is a realistic concern for a lot of people. And it's not that I'm not aware of that, but they cannot actually force you to go back to work. And so you have to consider what the consequences are of whatever decision you're going to make. But deciding whether or not to go back to work is not an insurance decision. It's not a legal decision. It's a medical decision. I'm not going to tell any of my clients when they should or should not go back to work, and your insurance company sure as hell shouldn't either. It's your doctors. That is who you need to rely on. Your doctors and also yourself. You should trust your gut on this. If you feel like it's time to go back to work, if you feel that you are reasonably recovered and that there is a pretty good chance that if you tried going back to work that you would succeed, then it's time to explore that. Short of that, it isn't. Now, if your insurance company says to you, we're going to cut off your benefits if you don't return to work, and your doctors are saying, no, you shouldn't, and you don't feel positive about it, then you have a choice to make. If you don't return to work, your insurance company is almost certainly going to cut off your benefits, and you just need to be aware of that. So your options are either listen to your insurance company and go back to work and white knuckle it for as long as you can and see how that goes, or don't. And if you don't, you're not going to get your benefits. Now, if you don't, I wouldn't leave it at that. And even if you do go back to work, I wouldn't leave it at that either. Go to your doctor first or your entire treatment team and have them put their opinion in writing. And in particular, if your doctors or therapists believe that returning to work at this point is not only ill-advised, but may actually harm you, may actually set back your recovery or cause some sort of exacerbation of your symptoms, it's really important that they put that in writing and that you put that in front of your case manager so that they have no choice but to incorporate that into their assessment. Now, I'm not telling you doing that is going to change their mind. It probably won't. But at the very least, if you decide not to go back to work and your doctors have put this in writing and you've put it to the insurance company and they've ignored it, if you want to challenge that decision, if you want to challenge the decision of your insurance company to cut off your benefits by starting litigation, you're in a much better position now. Now your insurance company can't say, oh, well, if we had understood what the treating doctors were saying that it was harmful, we might have come to a different conclusion. They can't say that anymore. Now they have made a decision ignoring what your treating doctors have told them. And that opens them up to, guess what? Punitive damages, what we talked about in the first segment. Also potentially aggravated damages if forcing you back to work actually has caused you harm. So that's a decision they don't want to make. So listen to your doctors first and foremost.
Second thing you need to know, disability benefits can resume if your return to work is unsuccessful due to what they call a recurrence clause, right?
Yeah, disability policies almost always have this recurrence clause built into it. So what is it? If you are on long-term disability and you recover to the point where your doctors feel it's okay for you to try returning to work, you can attempt to do so without necessarily risking the ability to have your benefits ongoing if you're not ready yet. Insurance companies want you to try to return to work, and so this is the way that they incentivize it, by putting in this recurrence clause that says if you try to return to work and within 6 months of your return, your disability, the same disability that caused you to go on leave in the first place, causes you to go on leave again, it's usually within 6 months, then you're entitled to continue receiving your long-term disability benefit. You don't have to start a new application. You don't have to wait for the waiting period or elimination period. Often that's 3 or 6 months where you're not getting any benefits at all. You are, in theory, entitled to just resume your benefits if you have to go on leave again within those 6 months. Now, in practice, it doesn't always work that way. In fact, far more often than not, what we find is when people try and go back to work and they're not successful, the insurance company doesn't say, okay, well, we really appreciate you trying. Here's your benefits again. Typically, it's actually met with something more like, no, we still think that you can work and we're not going to pay you anymore. And so then you wind up in a fight. Now, this isn't to suggest that you shouldn't try going back to work if you have improved and if you feel confident that you can return successfully and if your doctors agree. It's only to say that you should really wait until you get to that point before you do. Because short of that, you're very unlikely to be successful in your return. And if you're not successful, it means your benefits are going to be cut off anyway. So why go through that if you're going to cause further damage and you're still not going to get the benefits?
Again, returning to work after disability leave, what you need to know, final point is this: if your insurance cuts you off your LTD benefits after a failed return, now you can seek legal action. Yeah?
Yeah, I sort of got ahead of myself in that last answer, but that's really what we're talking about there. So if you do try and return to work and your insurer doesn't apply the recurrence clause, give us a call. Because if your doctors are saying that, no, your return to work showed that you're not able to continue working, then you're entitled to those ongoing benefits. And you give us a call. It's a free consultation. We go from there.
Well covered once again, my friend. We'll take a short break, come back with a phone question and some more of your emails as we continue more of the Disability Law Show. Hang in there. We're coming back.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, thank you so much for hanging on through that little short break here in the Disability Law Show. I want to tell you once again, anytime to reach out to James and his team, do so. The consultation will cost you nothing. It's a phone call away, 1-855-821-5900. Email to go with is help@disabilityrights.ca. And you can catch our radio shows all over as well. Simply go to disabilityrights.ca to find a station near you that carries our program weekly. James does that as well. He does everything around here. It's crazy. Phone call from one of our listeners coming up right now. Listen up.
My brother was given short-term disability, although that was quite a struggle, and he had to appeal it, and he did get short-term disability. But the person he's in contact with the insurance company was quite upset about that, and now she's telling him not to bother to apply for long-term because he'll never get that, and it just adds to his state of mind. He just wants to give up.
Don't bother.
Yeah, well, first of all, don't listen to your insurance company with that. So I presume this is a situation where it's either the same insurance company for both short-term and long-term disability, or the long-term disability insurer is the administrator of the short-term policy. Because otherwise, if it was a different insurance company, why would they even have an opinion on long-term disability? Now, here's the thing. Short-term disability and long-term disability, at least for the first 2 years of entitlement, have basically the same test. the own occupation test. You have a disability that prevents you from being able to do the fundamental duties of your own occupation. If you have that disability, you should be entitled to short-term disability benefits and then long-term disability benefits when they become payable. And so if you've been approved for short-term disability benefits throughout the entire short-term disability benefits period, that almost always is going to end exactly at the same time that the long-term disability benefits become payable. And so if one insurance company is making that determination for both short-term and long-term disability, it's very difficult for them to say, yep, you're entitled to benefits all the way up to here, but then here, no, you're not entitled anymore. It's just a random coincidence. Just happens to be the date it starts long-term disability. You're no longer entitled to the benefits that use pretty much the exact same test as we said you were entitled to a day ago. Unless there has been something that has actually fundamentally changed in your condition from one day to the next, then that's going to be a very difficult decision for them to justify. I don't have any medical records for this caller's brother. I don't know anything about the case, but I can tell you just by this scenario, it's pretty likely that they're going to be entitled to at least some term of long-term disability benefits, even if it's only for a few months, because the same insurance company has agreed to pay money throughout the entire short-term disability period. That's not really a scenario where you would expect to see a relevant denial.
Let's get to a quick email from Celine here. It says, I was put on long-term disability leave due to significant chronic pain. My doctor and physiotherapist have requested I be off work as work in a physical demanding job. After submitting forms to the insurance company, they deny my claim, saying I need more proof. I don't understand what other forms of documentation or proof I can provide. What can I do?
Well, chronic pain is a particular condition, and this was for, when I was first starting out in law, it was a very hot topic, and insurance companies were saying, no, it isn't something that should be paid for. It isn't something that should be compensable in a claim, be it disability or be it a personal injury case. And about 15, 20 years ago, there were a series of decisions by the Supreme Court of Canada, and they made it very clear. Chronic pain is a very real medical condition recognized by all courts in Canada, and when you have chronic pain and it's preventing you from being able to do your own occupation or any occupation after 2 years, it is absolutely compensable under a disability policy. There's no question about that. Here's the problem. Chronic pain is a subjective condition. Subjective conditions, again, are absolutely compensable, but the problem is that you don't have objective evidence. Subjective, that's the very definition of it. You don't have an X-ray that shows in black and white, this is your disability. It's based on the support of the medical community. It's based on your subjective reports of your symptoms and your functional limitations. It's based on the type of treatment that your doctors have suggested is going to be useful for you. All of these things are relevant factors in assessing whether or not you have chronic pain. And there are doctors that specialize in the assessment and treatment of chronic pain. And when they say that you have a disability, then that is who a court would rely on in those circumstances. The problem is, when you apply for disability benefits, they will often say, well, there's no objective proof of this disability. And so we don't really see it here. Yeah, your doctor says you have this, but we don't see it there. But guess what? The policy and the courts don't require objective proof of anything. If you have a disability recognized by your doctors, you are entitled to disability benefits. Full stop.
That's the way that works, and thank you so much for joining us. We got through everything that we needed to get through. If you want to carry on the conversation on your own with James and his team, invited to do so. Consultation will cost you nothing. That's nice. 1-855-821-5900 to reach out by phone. help@disabilityrights.ca is the email address. And for anything else, questions and otherwise, simply go to disabilityrights.ca. Links to our long-running radio shows as well, and we'll pick it up again next week with more. Thank you so much for stopping by, and we will see you next time right here on the Disability Law Show.